Within the judiciary, both judicial as well as administrative. She's a holder of master's degree in international business law from Uganda Christian University. May I beg your attention, please? Dear delegates, she's also a holder of postgraduate diploma in public administration and management from Uganda Management Institutes, a postgraduate diploma in legal practice from Law Development Center, and a Bachelor of Laws from Makerere University. In May 2024, Justice Olivka Mukwaya became the first female president of the Uganda Judicial Officers Association, UJOA, the first female ever since the association started in 1970. She's also the vice president of the National Association of Women Judges in Uganda, the Uganda chapter. Madam Justice, may I kindly welcome you to take the floor. You'll invite the presenter and also the discussants. Thank you.
Thank you, my Lord. My Lords, the Chief Justices, fellow delegates, participants in this conference, you're welcome to the second session. May I invite Chief Justice Othman to come and take his seat. He's the keynote speaker for this session. You're welcome, my Lord. May I invite Honorable Viola S. Mithoni from Kenya. Come and take your seat. From Uganda, we have the Honorable Justice Tadewa Simwe. You're welcome, my Lord. Rwanda, we have Honorable Justice Ruth Mukakalisa. Welcome, my Lord. Last but not least, certainly our host, Tanzania, we have the Honorable Aisha Sinda, Judge of the High Court. Welcome, my Lord. Now, as she comes, this session is titled Judiciary-Led Reforms in East Africa as a recipe for court efficiency and economic growth. Recently in Uganda, we had the unfortunate incident of having some of our leaders in the capital city arrested and charged for various offenses which began their journey in the criminal justice system in Uganda. These are leaders who had held positions of authority and influence for at least 4 years, and then they find themselves caught in the criminal justice systems. Leaders like you and me. It therefore becomes relevant for us to have a session like this one, where the efficiency of courts is at the center, improving that efficiency, because when you're caught up in the justice system, the stress and emotional turmoil that you have to endure demands that you want it to be swift and to end quickly, preferably in your favor. God forbid that any of us gets caught up in the justice system. But let's hear from our first presenter, and I will introduce him. The Honorable Justice Mohammed Chande Othman served as Chief Justice of Tanzania from December 2010 to January 2017. During that tenure, he was also chairperson of the Judicial Service Commission. He is currently Chancellor of RD University. In 2023 to 2024, Justice Uthman served as chairperson of the Presidential Commission on the Reform of the Criminal Justice Institutions. Since 2017, Justice Uthman has served as eminent person appointed by the UN Secretary General charged with investigating the tragic death of the second UN Secretary General, Dag Hammarskjöld, and others. Justice Uthman is also currently senior advisor to the prosecutor of the International Criminal Court. He is also chairperson of the UN Human Rights Council's International Independent Fact-Finding Mission for Sudan. My Lord Chief Justice, you're welcome to make your presentation.
Thank you very much. Honorable Chief Justice Juma, Chief Justice Hamis Ramadani, the President of our association, judges, principal judges, justices, registrars, magistrates, distinguished guests, good morning or almost good afternoon. Thank you for the invitation, and what I have been tasked to do is to share with you a number of perspectives concerning enhancing judicial foundation as cornerstone of the criminal justice chain. So what I wanted to do in the time allocated, and I know we are running out of time, so I wanted in the time that we have to share with you maybe 8 domains and to pause to interrogate ourselves as we go along to give an opportunity for the discussants to contribute. So by way of introduction, I think we all agree that all jurisdictions in East Africa have embarked on transitional frameworks, blueprints, or strategic agendas, by whatever name. And we share common goals, but with very specific particulars which are relevant to each country's context and situation. So it was said this morning here in Tanzania, you have 2 strategic plans and judiciary modernization program going on. Our colleagues in Kenya, they've had judicial transformation frameworks since the time of Chief Justice Mutunga, continued by Chief Justice Maraga, and now with social transformation through access to justice led by Chief Justice Koome. Uganda also the same strategic plan, and the same thing with Rwanda also having strategic plans. So all our region, we have strategic plans, we have blueprints. The second aspect of my introduction is that criminal justice, which is what we are centering, it has certain aims, and these are protecting society, the maintenance of public order, proper administration of justice, including victims of crime, upholding the rule of law, good governance, and everything that contributes to economic growth and stability and tranquility. The purposes of criminal justice, so they are tied to economic development, rule of law, and so on. But what I want us to pay attention is this. The dominant view, when one talks about criminal justice systems is that it is a network of distinct but multiple interrelated public enforcement agencies, in particular the police, the prosecution, the courts, and the prison and correctional services. This is the primary view, the dominant view. And if you look also, the definition of substantive law also follows that. That is the process through which the government can detect, apprehend, convict, prosecute, convict, and impose punishment upon those who have violated the prohibitions of substantive criminal law. However, in reality, and I think this is important for us in the judiciary, and we should, criminal justice in all its facets is much broader. It involves significant non-law enforcement agencies or agents and institutions. So you can argue the legislature is part of criminal justice because it legislates criminal law. There are other non-prosecution components: forensic science, community services, legal aid organization, the bar, human rights association, victim association in Rwanda, very powerful, Abuga, Survivors and Witnesses Organization. They are part of the system. But normally when we take a dominant view, we leave this out. And therefore the chain, we talk about the criminal justice chain, is somehow weak or broken. Another goal of criminal justice, we should remember, and this touches us at the center of what we want to talk about today, is that one of the aims of criminal justice is also to protect the innocent from false, erroneous, or unsafe convictions, but to ensuring also that the guilty are not granted erroneous acquittals. And that is our central role as leaders of the judicial chain. And I think you know the famous saying by Goldstone, it is better that 10 guilty persons escape than one innocent suffer. That was said in the 1760s. But also in criminal justice, and we should look when we are here today, is that it has different stages: investigation, prosecution, adjudication, conviction, sentencing, incarceration, rehabilitation, reintegration into society. So how does different stakeholders in the justice system deal with this, and how we, the court, as the cornerstone, are approaching these issues in relation to or with other colleagues? So that was my first point. The second one, what I would say is, what is the status of criminal justice in East Africa? So we can measure ourselves, but we are also measured externally. And for once, I just want to take, I don't always agree with the external indexes. There are many indexes of good governance, rule of law, and so on. But I just take one, and I think let's be objective and see what others say about us, instead of we looking at ourselves. I know all our judiciary, we have our own performance reports. So this is from the World Justice Project Rule of Law Index 2023. So criminal justice is measured. There is a factor 8, and this center on the courts, judiciary, and the central criminal justice chain. And they have 7 subsectors: effectiveness of criminal investigation, timely criminal adjudication, effective correctional services, impartiality of key judicial components, corruption-free criminal justice, criminal system is free from government influence, and respects of due process rights and the rights of accused persons. So you see, those subsectors involve the judiciary, but they are tied up also with other members of the judiciary chain in terms of the ranking. 2023 in East Africa, those who are here, Rwanda ranked 41 out of 142, Kenya 87 out of 142, Tanzania 96 out of 142, Uganda 115 out of 142, and DRC 129 out of 142. They may be right, they may be wrong. The message is we are performing, but we need to perform better, and we can perform better. In what way? Let us see together in the coming. When we look at the performances of the judiciary, let us also discuss the performances of the other sectors. So the third thing I wanted to share with you is the experiences in the Tanzanian Comprehensive Judicial Review, Criminal Review, 2023-24. There were many, many findings, but I just take out a few findings. And I think when you make the diagnosis, I think they will mirror other countries in East Africa. Tanzania, like many countries in the Commonwealth, did not have a national crime prevention and detection policy. No other country in East Africa has that, or in Africa. India is drafting one. Law enforcement agencies were more focused on criminal investigation and arrest, and not significantly on crime detection and prevention. Criminal justice agencies consisted of a web of over 40 institutions. So you see, we had a dominant view, only 5. There are in Tanzania more than 40 or 45 who are involved. To what extent, when we talk about stakeholder engagement, we are linking with the other? What relationship do our judiciaries have with the parole board, with the insurance companies? They are involved in traffic offenses, in compensating victims of crime for those motorists who are convicted by the court, and so on. Another one is multiple agencies and public officials in Tanzania have been granted powers of arrest, which were at times abused. And many agencies, apart from the police, were under law entitled to have places of custody. So not only police station, many other places of custody in which the police themselves sometimes did not know, including arrest powers. Many people have the arrest powers. Multiple institutions had overlapping mandates, engaged in criminal investigations. Criminal investigations were lengthy. There were forced confessions, were an occurrence, and I think we know this very well, for judges who try murder cases, and you have to go through trial within a trial. So the burden is on the court, but who does the forced confession is another institution. How do we make judiciary efficient that way? Excessive force, bail denied, including for bailable offenses, and an astronomical rise in mandatory non-bailable offenses, resulting in pre-trial custody prolonged and violations of the right of accused. When we had independence in Tanzania, we had 3 crimes that were mandatory non-bailable: treason, misprision of treason, and murder. We have now over 51 and more non-bailable offenses. 23 pieces of legislation needed amendment or reenactment. Plea bargaining process, which began in 2019, had made challenges, but it has, of course, improved challenges of transparency and so on. Prison overcrowding was chronic, non-use of non-custodial sentencing, The criminal justice institution operated a multiplicity of information and management system, and they were not really sufficiently ICT networked, and they were thinly resourced, but also a mindset change was the most essential requirement in criminal justice transformation. So we came out with 333 recommendations which are being implemented, including the judiciary is also a key player. In fact, the Chief Justice last year promulgated the criminal procedure, audio and video recording of interviews with suspect rules, because, as I say, major complaint about interrogation by the police in custody, which again burdens the court in terms of justice delivery. Now, zooming in on the cornerstone of criminal justice and the courts, I think there are 6 things I think that I want to propose to you. And one is our role as courts and our constitutional duty. So we are the guardian of the Constitution. We have powers of final interpretation over the Constitution. We are mandated to protect and enforce fundamental human rights. And they are key: right to a fair trial, legal representation, right to be proved innocent, right to legal aid, and so on. And the question for us is, to what extent are we interpreting the Constitution in a manner favorable to fundamental rights in criminal justice? Okay. Over the last 5 years, let us take, what key decisions have we rendered protecting fundamental rights of significance, most significance to development of criminal justice in our jurisdictions? So that's a question that I pose on the first. The second one is on criminal law, criminal procedure, and evidential reform, and the role of the courts and the criminal justice chain. So here, there are a number of issues that arise. One is the reform in substantive criminal law. What have been our initiatives in reforming substantive criminal law? Or are we aloof and waiting the legislature and the government to move into that domain? But the second aspect of criminal procedure is procedural technicalities. All our Constitution, Article 159, Sub-Article 2D, the Constitution of Kenya, Article 107A, Subsection 2D, Constitution of Tanzania, Article 126, Subsection 3 of the Constitution of Uganda, say almost the same thing as a principle, that the courts have to administer justice without due regard or being tied up with procedural technicalities which may obstruct dispensation of justice. So irregularities is key. Who occasions those irregularities? The judiciary or stakeholders in the chain of criminal justice? And irregularity, procedural irregularities, you know, in criminal law, there's a distinction also with civil law, because in criminal law, they may vitiate proceedings. And where conflict exists between protecting the innocent and other objectives of a criminal justice system, protection of the innocent almost always prevails. And irregularities occasioning miscarriage of justice or prejudice or unfairness to an accused may warrant quashing of the conviction and so on. So as I said, who among the stakeholders is occasioning these procedural irregularities, and to what extent are they a burden to us? judicial officers in dispensing justice. Another issue is in relation to evidential reform. Our Evidence Act, Tanzania, Uganda, in fact, surprisingly, the Evidence Act of Uganda is kept 6, and Tanzania is also kept 6. So there's no competition there. Okay? All of them originate from India, from the Indian Evidence Act of 1872. Okay? So why do we have a law which is over 100 years old, and we all know, we practice it, and we know how difficult, how outdated it is? Okay? What is a fact? What is a fact in issue? What is this and that? Admissible, non-admissible, and so on. And in criminal justice, one of the issues we found out in the criminal justice system is about exhibits. We found that the police in Tanzania had almost over 11,000 exhibits in police stations all over the country. Okay? So these were the system of management. There is no information system between the police, the prosecution, and the court. Because some of those exhibits which have been entered in court to be destroyed, you need a court order. Okay, the initiative must come from whom? Not from the court, from the prosecution. Okay, and so forth. So there's a new system for exhibit management. But in fact, when you talk of evidence, even in the International Criminal Court, they have moved away because there's a lot of litigation around the admission of exhibits in court. A lot of litigation. So the ICC has moved away from admission to submission. Submission of evidence, they moved away from admission of evidence to submission of evidence. You submit and let the court do the triage, assess the validity, the reliability, the credibility of evidence. They've moved away from admission. So I'm saying this evidential reform. The other aspect that I want to say is about adjudication, which is really for us one of the most central. And this is about case backlog and case backlog and caseload, and how we are managing that. Of course, there is a drastic improvement in the question of backlogs, but still it is a perennial issue that need to be discussed. I know judges have workloads, very heavy workloads, but I think in education there are many issues that we can discuss here, and I want the discussants maybe to share experiences. Delays in criminal investigation and how they're affecting the courts, how charging and prosecutorial policy influence decisions, the question of plea bargaining, the question of trial and appellate jurisdiction, the question of use of forensic sciences, especially in gender-based crimes. To what extent is DNA being used systematically for all gender-based crimes, in particular rape, gang rape, some of those offenses? And then compensation to victims of crimes. I think in most of our laws, victims of crime are shortchanged in terms of compensation or reparation for the harm that has been done to them. Another issue in adjudication I want to raise about miscarriage of justice, and this occur, of course, do not occur in a social legal vacuum. The police, the prosecution, forensic experts, it has been documented, have contributed to wrongful conviction. But what I found out in looking at miscarriage of justice is the data or the performance or annual reports of the Rwanda. Maybe our colleagues in Rwanda can help us here, because one of the measurements they use is the rate of overturned convictions. I think other countries, we don't do that. Okay, what is the experiences in measuring overturned convictions? Okay, I know judges sometimes when they are overturned, they are embarrassed, but I think it's a learning process, because maybe it's a higher panel and so on. I think let me reach out to two other things before I make concluding remarks, given the time allocated. And the other is about corrections and sentencing reform. That it is the court that renders sentencing, but sentencing cannot adequately be treated in a relative sense limited only to the challenges confronted by the sentencing judicial officers. So there's the issue. Sentencing also is one subject in which involves interrelationship between the different components of the criminal justice chain: the prosecution, the court, the prison correctional services, community services, but also the executive, the legislature, and the judicial branch of government have direct interest in sentencing policy and sentencing laws. So sentencing is an issue, and one of the issues in sentencing is about mandatory sentences, okay, and the elimination of judicial discretion in sentencing. The other issue also in sentencing is about the use or non-use by our judicial officers of community services order. If you look at the panorama in East Africa, we are varying degrees. I think Kenya uses it the most than other countries in the region. Okay, but this non-custodial sentencing as a way of reducing prison overcrowding. Okay, the chairman of the Uganda Human Rights Commission was saying the other day, in Uganda, prison overcrowding is out of control. Chairman of the, is not my saying, of the Uganda Human Rights Commission. Justice Maraga, when he did a review of the institutions in Kenya, said it is perennial, and there is data there in the report of the Maraga task force. So to what extent are we in the judiciary taking into account prison overcrowding when we are dispensing sentencing? Is it a factor or not a factor? Because it affects another institution in the justice chain. Okay, last year in the UK, the minister, the Secretary of Justice even advised the courts to stop sentencing because there were only around 300 spaces left in prisons in the UK. They had almost 88,000 inmates. Yeah, and then the ultimate issue that I raise is about the courts and stakeholder engagement. So I think the saying goes, a chain is as strong as its weakest link. Stakeholder engagement, I think it's very good in your strategic plans and so on, is a component of your transformation framework, of your strategy. Stakeholder engagement, I think we talk the same language in terms of who to reach out, but I think it's important to reach out, as I said, not those key institutions, but there are others also that may influence our work. And Tanzania, I think, judiciary took the lead in the integrated justice centers also, where you have other operators of the system in the same venue, the prosecution, community services, juvenile issue dealing with juveniles and so on. And so there are cross-cutting issues that I think we in the justice chain institutions need to look at together about witness protection, as I said, the management of exhibits, legal representation and legal aid to the indigent, and so on. And again, another key player is the bar associations. And this bench bar, close cooperation, to what extent is it effective in our jurisdictions, really helping us to render criminal justice. So in conclusion, I think when you look at criminal justice, the role of the judiciary, the court, and the stakeholders, there are, I think, 4 issues that I would like to suggest. One is really that we need to be always conscious that there is a need to increase and to multiply public trust and confidence in the criminal justice system and its institutions. And I think I'm glad our judiciaries undertake nowadays the surveys, opinion polls or the surveys, in trying to know the public to what extent they have confidence in the judiciary. We found out in the criminal justice review some of the institutions very low public trust. I think if we want to continue to be the cornerstone of criminal justice, our transformative agendas and blueprints, we need to continue to take strategic leadership. And for me, strategic leadership is not only with the Chief Justice. Strategic leadership and the commitment and the will must be for all judicial officers at whatever level. Okay, so I think you as members of Eamja should take the lead vis-a-vis your colleagues in providing strategic leadership also. It's an added burden, added responsibility as Eamja members to continue to have this multiplier effect. The third proposition I want to make is the criminal justice chain. It needs to be a coalition of the willing. You need to have in these institutions a critical mass of champions who are ready to transform their own institutions, including to seek close cooperation and linkages with other stakeholders. So we can be running 100 kilometers an hour, but if the police is far behind, okay, they are not reforming, it will affect our performance. It will reject our judicial strength, our delivery. To the extent possible, give them a hand. Of course, it is their responsibility, but we can give them a hand. We can suggest, and I know in your decisions sometimes people ask, is not your job, is it your job? To tell in a case, you say, well, this case has been poorly investigated. I've read it in judgments. Okay? This case has been poorly investigated. It means, you look, the judge is very furious. Yeah? Yeah, because, I mean, come on, you're wasting my time. Yeah? We had a case once, I was in the court once in a case. One of the assistant commissioner of police, he signed a search warrant. He did not call any other third party to witness the search warrant. And the GPO says clearly you must find a third person uninterested to sign the search. Of course, the court rejected that warrant, the search warrant. And then I think finally, is this requirement for mindset changes in members of all the judicial chain, including the court, but also sometimes the public. Okay, mindset change in the public also, because you know the public not many times also want stiff sentences for minor crimes. Okay, so I wanted to share that, but my idea was also to raise some issue and to give a chance also to discuss to give us the latest in terms of development in their own jurisdiction so that we can make this a lesson learned exercise. I thank you very much.
Thank you, my Lord Chief Justice. Another round of applause. Just to remind ourselves, he was working on enhancing judicial foundations, courts as a cornerstone of the criminal justice chain. Those are big words. And he has given us a lot to think about. Thank you, my Lord Chief Justice. We were told earlier that this engagement here at the Eamja conference provides an opportunity for continuous learning and engagements, meaning the problems are systemic, and therefore the solutions must be timely and appropriate for the season. And they must come from us. So let's hear from Kenya. Our first discussant is the Honorable Viola S. Muthoni. Just give me a second. Viola S. Muthoni is a resident magistrate and lead adjudicator of the Small Claims Court, Mombasa, Kenya. Having been admitted to the Kenyan bar in the year 2011, she has over 12 years of work experience as a litigator in civil and criminal law. Viola served as a prosecution counsel at the Director of Public Prosecutions, Kenya, for 7 years before joining the judiciary of Kenya in November 2021. At her current role, Viola works together with 2 other adjudicators to determine small claims within 60 days. From the date of filing. She supervises the staff of 6 of the Mombasa Small Claims Court Registry, chairs staff meetings, and signs the Performance Measurement and Management Unit, a monitoring and evaluation tool against which courts are measured in Kenya against set targets on behalf of the Small Claims Court, Mombasa. Viola holds an LLB degree, honors from Kampala International University, Uganda, a postgraduate diploma in law from the Kenya School of Law, and an LLM cum laude in transnational crime and crime prevention from the University of the Western Cape, South Africa. Viola enjoys making new friends and hearing their life stories. Honorable Viola, you're welcome to make your presentation. A round of applause.
Honorable judges, honorable CJs, colleagues, ladies and gentlemen, good afternoon. It is my utmost and humbling pleasure to respond to some of the issues that have been raised by the Honorable ex-CJ of Tanzania. So mine is to share the Kenyan experience and I will address the issue of the extent to which the courts in Kenya have interpreted the Constitution in matters of criminal justice. So I'll begin by stating that our Constitution has been lauded as one of the most progressive, given the provisions it has in the Bill of Rights. And the Kenyan courts have been at the forefront of protecting human rights, especially for the vulnerable. So in the criminal justice system, usually the accused person is vulnerable as they are pitted against a very well-resourced state prosecutor. So as the Honorable Moderator, Honorable Olive has said, even if it is one of us who finds ourselves on the other side of the dock, still, as compared to the prosecutor, you are still vulnerable. So then, the courts in Kenya have advanced interpretation of the Constitution in a purposeful way to protect the rights of the accused. I will give an example of the cases. In the case of Francis Kariuko Muratetu, the Honorable XJ has spoken about the mandatory death sentences. So in this case, the mandatory death sentence for murder cases was declared unconstitutional. So there was a follow-up advisory by the Supreme Court clarifying that this only applied to murder cases, but there's a leeway for the accused persons to petition for the same to be applied for other offenses. So the courts have also addressed the rights of the mentally ill who are in conflict with the law and declared some sections of the penal code unconstitutional for how they deal with mentally ill persons. When it comes to the rights of victims, the High Court in Kenya has expanded the meaning of a victim to include companies and other juridical persons in criminal cases. So there's a quote by 4 judges of the High Court, one of whom is seated here with us, in the case of Coalition for Reform and Democracy and 2 others versus Republic of Kenya, where the court stated that the rule of law is thriving in Kenya and the courts shall stand strong, fearless in the exposition of the law, bold in interpreting the Constitution, in upholding the judicial oath. So other key cases include a case that involved a petition for a habeas corpus petition. I apologize. So in the case of the Law Society of Kenya versus the IG, this was an application for 3 persons who had been disappeared during the protests against the finance bill. And in this landmark decision, the acting Inspector General was held in contempt for failing to appear in court to explain where these people were. Interestingly, he failed to appear, and on the day when he was to purge the contempt, the 3 gentlemen reappeared. So this just to say, of course, the court's impact can be felt. On the right to fair trial, there has been several cases, including the case of Massimo Gore versus Republic, where the court held that the appellant's right to a fair hearing was infringed by the failure of the magistrate to comply with Section 200. This is the one that allows the accused person to apply for a rehearing of the case where the magistrate has been transferred. So there has also been cases on the right to bail and bond, including anticipatory bail, Also, there are cases on contravention of human rights, where state officers can be held personally liable where they contravene the rights of an arrested or accused person. So we also have a case on the prisoner's right to vote. So prisoners in Kenya are allowed to vote as long as they have not committed an election offense. So I would say that the Kenyan courts have played a transformative role in enforcing fundamental rights and freedoms for accused persons, suspects, and the public. There has been some laws that have been declared unconstitutional for being in contravention of the Constitution. This includes sections of the Penal Code, which I will not go through because of time. Criminal Procedure Code, Prisons Act, Victim Protection Act. So to highlight on the Victim Protection Act, the courts have allowed victims to participate in the trial, but where the rights of the victim are in conflict with that of the accused person, then those of the accused persons prevail. So we also have the National Police Service Act, Computer Misuse and Cybercrime Act. So what is the role that the judiciary has played in summary? The one I've stated of declaring some provisions unconstitutional, issuing judicial directives, promoting jurisprudence, applying substantive justice as opposed to procedural technicalities, stakeholder engagement, acting as visiting justices to prisons, applying policies, including the bail and bond policy, sentencing policy, active case management guidelines, use of IT to enhance access to justice, and also this one I can say there's the issue of conservation. As the Kenya judiciary, we have moved 100% online, and the goal is to go 100% paperless. So I will also comment on the issue of substantive justice versus procedural technicalities. So Article 159(2)(d) of our Constitution says that justice shall be administered without undue regard to procedural technicalities. We have seen our courts implementing this. On the legal and policy reforms, the judiciary has put in place the policies that I have mentioned. There is also the promotion of plea bargaining and diversion. So for diversion, maybe a point to note is that for children, they are considered automatically for diversion before they can be charged. So there are also institutional reforms, including performance management, promotion of alternative dispute resolution, training and capacity building, adoption of technology in trial. So some of the challenges and have been alluded to by the XCJ include resistance to change, resource constraints, and limited awareness. So for our stakeholders, there are some also challenges that we experience, including failure of them to avail police files, poor drafting of charge sheets, some of which have led to acquittals of accused persons. So for the ODPP, Office of the Director of Public Prosecutions, there are also challenges. But with stakeholder engagement, we can all surmount those challenges. So for the stakeholders, the police, the ODPP, there's also correction services and other supporting institutions, including the Children's Department, probation and aftercare, witness protection agency, civil society organizations, of which there must be proper coordination for us to ensure that the goals are met. So for recommendations for improvement, the legislature should provide clearer guidance, and when the court gives them the directives, once some sections of the law are declared unconstitutional, the court directs that amendment or reform to the law be done, but we have seen that this does not always happen. So I see my time is up. So maybe to just comment on sentencing. So for this, largely the court applies the sentencing policy guidelines, and the proposal here would be to put this in statute so that there's a more uniform application of it. For prison overcrowding, that is a problem as well in Kenya. So the proposals that have been made should also be implemented there. Yes, so let me stop here in the interest of time. I thank you so much for the opportunity.
Another round of applause. I apologize in advance about the time. I'm going to be quite strict about it because we're trying to redeem time here, but we appreciate the richness of the presentations thus far. Our next presenter is the Honorable Justice Tadeo Asimwe. The Ugandans can clap if they have hands. Honorable Justice Asimwe is a distinguished legal professional from Uganda. He holds a Bachelor of Laws honors from Makerere University, Kampala, and a postgraduate diploma in legal practice from the Law Development Center. He also earned a master's in business administration from ESAMI, the East and Southern Africa Management Institute. Throughout his career, Honorable Asimwe has held various significant positions, including serving as the project advocate for the Legal Aid Project of the Uganda Law Society, a state attorney in the DPP's office, and a resident state attorney in multiple jurisdictions in Uganda. His extensive experience in the legal field includes roles such as associate partner at the Law Development Center, principal legal officer at the Judicial Service Commission, and deputy registrar at the High Court of Uganda. From 2014 to 2018, Honorable Asimwe served as the registrar at the Inspectorate of Courts and the Court of Appeal. He then took on the role of resident judge for the Mbale High Court Circuit and later the senior resident judge for the Mbarara High Court Circuit. Currently, he is the deputy head of the Land Division, having previously served as the deputy head of the Criminal Division. Honorable Asimwe has also demonstrated leadership in various capacities, including as the Guild Speaker at the Law Development Center, the President of the Uganda Judicial Officers Association, and Chairperson of the National Community Service Committee. His contributions to the legal profession and his commitment to justice have been significant and impactful. My Lord Justice Tadeo, you're welcome. Please welcome him.
Thank you, my Lord Justice Olive, my Lords, the Honorable, all the judicial officers in this room. 10 minutes is very little, as you all know. And my Lord here, Olive knows that when a paper is presented by a distinguished retired Chief Justice, it is a cocktail of issues. And therefore, I'll be very brief so that we allow the audience to discuss. Thank you, my Lord, for emphasizing that we have the mandate and the role to promote and protect the rights as enshrined in our various constitutions. And I agree with you entirely that we are being called upon not to abdicate our duties, and that is very, very key. And therefore, we should work as leaders. We should take the lead. Those are very, very critical. If I got you right, he called upon us to be in charge. We are judicial officers. Are we in charge of our courts? When things fail to move, do we throw our hands in the air? And the message is no, that should never happen. He has called upon us to be the leaders of the teams. Administration of justice is a chain, I agree entirely. And it is a process right from arrest up to sentencing. And therefore there are a number of innovations which are going on throughout our judiciaries. And therefore we're here to share the positives for our different judiciaries to replicate. The issue of case backlog is alive and kicking in Uganda. Prison congestion, there's no debate. And therefore the call for alternative ways of sentencing is very, very, very critical. What are the innovations Uganda is doing in these areas? In the fight against case backlog, first of all, Uganda Judiciary has established the Case Backlog Committee, which is alive and kicking, headed by the Honorable the Deputy Justice seated here. And every quarter, we review and see performance. And in that regard, as we speak now in Uganda, we have fully embraced the ADR system, again headed by our current Honorable DCJ seated here. So we have ignited the engine by recruiting retired judicial officers, advocates, and other professionals attached to various divisions to do ADR, mediate, because we have realized we can never finish the cases through the litigation. It is not possible. And we are seeing results, they are coming. And I thank the retired CJ who said, we must work as a team. In the area of ADR, we have noticed that the bar plays a very key role, and because they provide advice. So once they resist the processes, you are likely not to achieve a lot. Since we are sharing countries' perspectives, in Uganda today, we have embarked on the system of training the bars well, in addition to training the mediators. These mediators have been now accredited, and they sit in our courts. So because we saw the resistance of the bar, we are now bringing on board training of the lawyers so that we run as a team, as it has been suggested here today. Small claim, just like Kenya, it is alive and running in Uganda. Every magistrate now deals with those matters, and we do not allow advocates to participate. Some lawyers have challenged the processes, but it is giving us good results. Judicial officers determine those matters in a day. Some are seated here in this audience. One day, small claim case is done. You issued a check, it bounced. How much money? 1 million. The check is tendered in court. The magistrate issues the order for you to pay the money. Case closed. Very fast speed. Plea bargain is another intervention the Uganda judiciary is doing. And there are sessions running throughout the country where prisoners give us a list, we go and deal with those cases. And it is doing wonders. It is saving government money, and the results are very positive. I will encourage all our judiciaries to embrace plea bargain. It is a nice thing. Plea bargain, small claim, ADR. If you want to take out any message from this gathering, those three, don't forget. They are very nice. They have shown that it works in Uganda, and therefore we encourage our sisters and brothers to pick a leaf. Those three. In the area of congestion in prisons, I happen to be the chairperson of the National Community Service Program in Uganda, and therefore I spearhead that process. We encourage all our magistrates to grant non-custodial orders by way of promoting community service programs. And it is also doing us well. The only problem we have is that it is limited in scope. It's only limited to offenses which are misdemeanors. There's a consultancy going on to see whether we can extend that program to capital cases. There is an argument that if a judge can caution a convict in a capital offense, which some of us have done, I'm told, if you can caution somebody to go home in a capital offense, why can't you tell a convict to do 2 hours on the roadside and pick rubbish in a non-custodial order? That one will come is for the future. Also, we have developed sentencing guidelines which are operational in all courts, which guide judicial officers in the ranges of sentences they pass. It is helping us in trying to come up with some kind of uniformity in sentencing. In the area of juvenile justice, there's a lot in the paper. I'll jump here and there. Juvenile justice, recently in Uganda, a decision has been taken because we have been facing a challenge of producing juvenile to our courts. So we have now turned the remand homes into courts so that they don't need to come to court. Instead, the judicial officers will be sitting in the remand homes, solving the problem of transport. That is in the area of juvenile justice. In the area of witness protection and also transport to courts, we have embraced the audio of these visual links. The courts in Kampala and a number of high courts are connected to the prison facilities. As we speak now today, you can sit here and hear a case and finish it without an accused person being produced physically, and even pass a sentence while he is seated in prison. And we think that is a positive. It saves on transport to bring this person. It deals with the issues of security and the costs, as you know, saves the budget. We are doing that. In the area of reparations, as those of us who have been following, our Penal Code Act allows compensation in all these cases, be it rape, be it defilement. Those provisions are available in our laws, but at the same time we are now dealing with the issue of reparation. We have recently concluded a case of Coelho in the International Crimes Division. Their lordships, as we talk now, have returned to the court to deal with the issues of reparation. And so, in that area, we are on the road, moving. Now, the other aspect is on gender. In the area of gender, SGBV sessions are being held, dedicated sessions, where their lordships are assigned to do sessions to fast-track cases of SGBV. So we give them special attention. And we think in that way, we'll be able to move forward and protect the victims in those systems. And by way of conclusion, since my time is over, our judiciary in Uganda has embarked on a very serious decentralization process after copying from our sister judiciaries, whereby the high courts are being decentralized in different areas, and their worships, the magistrates, are also now being deployed, and the policy is to reach a constituency. We are now deploying, and as far as judiciary-led innovation is concerned, for us in Uganda, we lead in everything. We are the first to start a court, then the prosecution will follow. So we are not shy in doing that. Our judicial officers are now even complaining they have nowhere to sit, but they are deployed. They are there. We want to see justice nearer to the people and smooth and efficiently given to the citizens. I thank you for listening to me.
Another round of applause. Thank you, my Lord Justice Tadeo. My apologies again. We are pressed for time. I'm going to invite Rwanda next. And from Rwanda, we have the Honorable Justice Ruth Mokakalisa. She's a judge of the High Court in Rwanda since 2012 and served in different lower intermediate courts for 7 years prior to that. She also served as a member of the Executive Council of the East African Judges and Magistrates Association in 2015. She holds a master's degree in public international law from the Kigali Independent University and holds a certificate of graduation from the OXID Executive Leadership course from the Institute for National Transformation. My Lord Justice Ruth, you're welcome.
Thank you, moderator. Honorable Chief Justice, distinguished judicial officers, picking from the presenters, picking from what the presenter said, I would like to share with you Rwanda's experience about cooperation of stakeholders in the criminal justice chain. As it sounds, criminal justice chain does not work in isolation, as it is made of different stakeholders. The judiciary connects to stakeholders digitally with regard to case processing and management. It again cooperates with stakeholders in some procedural legal issues to enhance efficiency in the criminal justice system. Digitally, the judicial system is connected to other 4 institutions of the justice sector, that is the National Public Prosecution Authority, the Rwanda Investigation Department, Rwanda Correctional Services, the Ministry of Justice. Each institution having its own platform through which it operates. They all merge through the Rwanda Integrated Electronic Case Management System, and through this system they are all able to make a case flow follow-up at all stages of the proceeding, meaning that the assigned judge can access the Rwanda Investigation Bureau and the Public Prosecution Authority case file with all related documents. In brief, the prosecution, defendant, victims, and lawyers who wish to make submissions to the court do it simply by opening an ISMS account and indicate their full address and contacts, through which they get automated notifications about the progress of a case. And once they have been linked, they easily track the case status wherever they are, such as case schedules and accessing judgment copies. All they need is to have access to internet, thus making this system accessible, less costly, time-saving to litigants as advantages among others. Basically, as part of a holistic approach of the judiciary, access to court system has been put at the forefront as a fundamental building block for a fair judicial trial process in promoting the right to access to justice. The other fundamental judicial reforms made is the introduction of common law concepts in the Rwanda inquisitorial civil law system. The Rwanda law reforms has introduced concepts like the pre-trial sessions, cross-examination process, and pre-bargain processes. These incorporations have made the system a hybrid kind, making it, being it predominantly a civil law system. The criminal justice system applies best practices from the common law system. Beginning with the pre-trial session, it is a preliminary session held before a case is tried on its merits, for purposes of handling a smooth and speedy trial later. A pre-trial meeting, when held, enables the judge to examine incidental proceedings which would otherwise delay trial on the merits of a case, and they are sorted out in advance. Such incidents examined include the court's jurisdiction, identification of witnesses of each party, their number, and protection. In this process, participants include the prosecution, suspects, and victims who wish to file for damages. They participate in clearing irregularities that would lay a case trial. The other common law concept introduced is the cross-examination. Previously, as a civil law practice, witnesses would testify in court before the judge, and the judge asked questions for clarifications, but the prosecutor and suspect would not examine in chief, cross-examine, or examine witnesses. Engaging parties in this process plays an important role in the context of discovering the truth about the matter and eventually complements other evidence presented to the court. The other innovation introduced to enhance cooperation in the Rwanda criminal justice chain is the introduction of the pre-bargain procedure, which is based on a pre-bargain agreement between the suspect and the prosecutor. In this process, the court joins at a phase of holding hearings when a lot has been done and truth has been revealed about the case at the investigation and prosecution phases, hence contributing to minimizing the risk of committing errors in decisions taken. The other advantage is that the judge tasked to confirm parties' consent to the prior agreement does not take long, as the suspect pleads guilty to gain pre-bargain benefits. Thus, this speeds up case disposal and subsequently reduce case backlogs. And I have to mention that to ensure its efficiency, there is a pre-bargain advisory committee chaired by the Chief Justice, and the members And other members include the prosecution, Rwanda Investigation Bureau, Rwanda Correctional Services, and the Bar Association. This commission has the overall objective of overseeing the implementation of the pre-bargain process from the prosecution to courts. Further still, in light with discovering the truth about a matter to avoid committing errors and miscarriages, in criminal trials, as you know, the civil law system being predominantly inquisitorial does not keep a blind eye about the prosecutor's weakness in processes. The law requires the judge to play an active role in the trial process. This means that the judge does not dormantly sit back and wait to announce the winner at the end of the process. It is legitimate and lawful for the judge to order for the production of evidence he or she notices that it will assist in revealing the truth. As you may well know, the inquisitorial criminal justice system is more truth-based than proof-based, and the Rwanda combines both to acquire truth and proof, meaning that the prosecution weaknesses in evidence production does not necessarily mean an acquittal. To sum it up, these new reforms have been adopted to enhance efficiency in the Rwanda criminal justice system and ensure the provision of quality justice with the overall objective of the respect of the rule of law. I thank you so much for your kind attention.
Thank you, my Lord. Thank you so much for that. Our next presenter is from the host country, Tanzania, my Lord. Justice Aisha Sinda, Judge of the High Court of Tanzania. She holds a law degree from the University of Dar es Salaam. She also holds a postgraduate certificate in economic law and competition law from the European Institute of Foreign Studies. The judge also holds an LLM in international trade and investment law in Africa from the University of Pretoria. And the CV goes on. My Lord, you're welcome to give your presentation.
Thank you very much, Honorable Moderator. I'm the last speaker, but not the least. My name is Aisha Lisinda. As I was introduced, I'm a judge of the High Court of Tanzania at Mbeya. Our distinguished guest, as you observed, Tanzania is very huge, and Mbeya is a highland region in southwestern Tanzania. It is also called the Green City. Our Chief Justice earlier in his opening remarks said, and I quote, "We should break down the protocol barriers." I therefore humbly take this opportunity to break down the protocol barriers and welcome you all to visit Mbeya. You should not just end here in Arusha. In reacting to Honorable Othman's presentation, I'm here to give a country perspective on courts and criminal justice process in Tanzania. And my discussion will focus in the key major reforms that the judiciary of Tanzania has undertaken so far in order not to delay the delivery of criminal justice in Tanzania. As presented by Honorable Othman, the President of the United Republic of Tanzania formed a commission to look at how to improve the criminal justice system in the country. And the commission presented its findings and recommendation to the President in July last year. Some of the issues raised by the Commission were on the integrated use of ICT by the core stakeholders involved in the criminal justice system, the untimely issuance of judgments and proceedings, the procedure to record caution statements of accused persons during interrogation by the police, the abuse of nolle prosequi by the prosecution, insufficient legal training in different key areas to judicial officers and other key stakeholders, and the procedure in plea bargaining and sentence reforms, just to mention a few. As a result, the judiciary of Tanzania has taken various steps to implement the recommendation of the Commission. And the judiciary focused mainly on the judiciary of Tanzania vision that is timely and accessible justice for all, and Pillar 2 of the judiciary of Tanzania strategic plan, which intends to enhance access to justice and expeditiousness. So some of the key reforms which we are taking is to spearhead and coordinated and integrated approach in the use of the ICT by the core stakeholders and institutions involved in the criminal justice system. That is the citizen, the police, the prosecution, prisons, just to mention a few. Further, the judiciary started to hear cases remotely in prisons through video conferences and introduced the e-court filing through the electronic case management system, which rolled out effectively in November 2023. And to properly deliver justice, the judiciary has gone completely online and paperless. As a result now, judgment, ruling, orders, decree, and proceedings may be signed electronically and can be accessed on the same day. These have been made possible by the use of electronic case management system, e-library, and Tanzli. So far, decisions which have been uploaded on Tanzli are more than 58,000. This efficient retrieval of information has significantly reduced the time and costs in the criminal justice process. Further, the judiciary has also incorporated artificial intelligence in its transcription and translation system for administration and access to justice, therefore breaking down the language barrier in Tanzania and aims to improve court efficiency. The use of ICT that has been spearheaded by the judiciary has also encouraged individual judges to utilize artificial intelligence-powered tools in case management, legal review, and research, and also to obtain valuable insights to support their legal arguments and decision-making process in the criminal justice process. Example of the tools that are used by judicial officers are ChatGPT, Grammarly, Google Translation, Zoom transcription and translation, Quillbot, Copilot, Canvas, and Gemini. In addition, the judiciary has introduced or amended rules, guidelines, and manual to address key strategic area in the criminal justice system. Like in Uganda, we have the Court Annexed Mediation Guidelines of 2024, which aim to improve the use of alternative dispute resolution. We have also introduced Tanzania Court of Appeal Amendment Rules 2024, which aimed at decreasing workload before the Court of Appeal. We have also made magistrate courts small claims procedure rules, which is adopted from the Gacaca courts, in Rwanda, and the rules do not allow for adjournments, and a decision is to be delivered within 30 days after a last date of hearing. This is more efficient and faster comparing to the normal procedure, which requires a decision to be delivered within 90 days after the date of last hearing. We have also introduced the Judiciary of Tanzania criminal procedure, audio and video recording of interviews with suspect rules, which aims to reduce complaints by suspects being tortured by the police during interrogation when taking the caution statement. Further, the Judiciary of Tanzania, in collaboration with the Institute of Judicial Administration, have introduced e-learning platforms which provide training to judicial officers and various stakeholders at an affordable price to equip them with the necessary skills on critical issues affecting the criminal justice system in Tanzania. For instance, we have had training on sentencing to make sure judicial officers align and have an increased awareness on the sentencing guidelines. Further, we have had trainings on plea bargaining on areas which lack clarity, especially on the procedure for plea bargaining. We also now have guidelines and rules specifically on plea bargaining. In conclusion, despite the challenges which we are facing in relation to the implementation of criminal justice system, such as being overburdened with heavy caseloads and suffer from insufficient financial and human resources, the Judiciary of Tanzania has received positive feedback from its core stakeholders on the reforms which have been undertaken so far. For instance, very recently, the Commissioner General of Prisons commended on the reforms done by the Judiciary of Tanzania, that the improvements in the judicial process have greatly helped in managing prison congestion. He added that the national prison capacity, which is 29,900 inmates, but currently the prisons are accommodating around 27,000 inmates. He attributed this reduction in number is directly related to judicial reforms in the criminal justice system, including timely hearing and determination of cases. Finally, as our Chief Justice earlier said, many countries are keen to learn from the Judiciary of Tanzania, particularly on our methods for enhancing justice delivery to citizens in the criminal justice process. We have received delegations so far from Malawi, Uganda, and Zimbabwe, to mention a few. This marks the end of my country perspective in relation to Tanzania on the delivery of the criminal justice system. Many thanks for listening. Merci beaucoup. Asante sana.
Thank you, my Lord. Now we're going into the interactive plenary. I'm going to take a seat, and whoever has a question, kindly raise your hand. Any response? We'll do this for 10 minutes and then go for lunch. Anyone can start. Yes, please, on the left. I hope you have some microphones. Anyone else? Please introduce yourself and then make your comment or give your question.
Okay, thank you very much. for this opportunity. My name is Olwande Evali from Kenya. I think first of all I want to start off by commending the retired Chief Justice Othman for the paper ably presented, and also all the presenters. And specifically what stood out for me, one of the things that stood out for me is the discussion around admission and submission that is being practiced at the ICC. And I was just thinking, for the rest of us, maybe we do want to go that way, because I see how it would enhance efficiency, especially in terms of time management. Because if you're going the admission way, by the time you've taken submissions on what is admissible, what is not admissible, you make an interlocutory ruling, there's probably an interlocutory appeal, so there's a lot of time wasted there. And I was just thinking, maybe as judiciaries in this region, we may want to look at that. But in terms of maybe my contribution, I wanted to just mention, retired Chief Justice also talked about having a coalition of the willing with the justice players. I just wanted to share maybe the Kenyan experience. We probably have it in other jurisdictions or not. But in Kenya, we have the National Council on Administration of Justice. I believe my sister would have mentioned had she been given sufficient time, but I appreciate the time was not on our side. But basically, it's a body that brings together all justice players for purposes of coordinating and ensuring that we are able to move together. So we are all able to sit at one table and discuss and see how best we can be able to improve efficiency for all the players so that we are moving as one and ultimately achieve our goals. Lastly, I wanted to ask, I also believe maybe in the interest, because of time, she was not able to cover that. Rwanda was identified for having a performance measurement framework that also factors in as a parameter the rate of overturned decisions. And that is something also, I also serve in the Judicial Service Commission in Kenya. So it is something even as a commission we've been grappling with, whether that is a parameter we really want to introduce. And of course, we appreciate the importance of that parameter. But I wanted to ask, how do you handle the need to ensure that judges and judicial officers are able to make decisions without fear of repercussions? I think even the principle of judicial privilege has behind it the backing that we want judicial officers and judges to be able to make decisions without fear that there'll be repercussions in the manner I have decided a particular case in good faith. I don't know how maybe the Rwandan experience, how you are able to guard against that. It will be good to share with the rest of us. Thank you.
Thank you so much. My Lord Justice Ruth. Justice Ruth, do you want to answer that right now? Please go ahead and answer the question.
Thank you for the question. Yes, they mentioned about the system, but I admit I'm not able to answer it very well, but my colleague here can assist. Yes, Geraldine. Please, can you assist?
Yes, please.
How the system works.
So the question is, using the parameter of the rate of overturned decisions on appeal a concern for Rwanda, given that it may curtail judicial independence? That's the question.
Thank you. My lords, all I can say is that for Rwanda, it's not an issue. We haven't been threatened. We have not had an issue. There is no judge that has had an issue. And so to us, it is all smooth. Thank you.
Thank you, my lord, for that. My Lord Justice Chiborion.
My question goes to the presenter. It relates to the problem of abuse of powers of arrest by the police. There's a growing trend where the police, in exercising their powers of arrest, beat up the suspects, sometimes even causing grievous bodily harm, sometimes causing disappearances, sometimes causing even death. What should the judiciary do to alleviate this situation if it cannot be eliminated?
Thank you, my Lord. My Lord Chief Justice.
Yeah, thank you very much. Well, maybe just briefly, just a comment concerning measurement of overturned convictions. Okay, this system is used in a number of countries, not only Rwanda, but I think also in some states in the US. And of course, in terms of measuring judicial performance, always two questions arise, which is qualitative assessment and quantitative assessment. And I think, as was said by our colleague from Kenya, is to ensure that judges are free, and we have to accept that in the dispensation, in judicial decision-making, some errors are inherent. I think there is a book called Bad Judges. Okay, it's a small book called Bad Judges. And it says that making one error is not a big deal, because there is an error in judicial decision making. Court of Appeal make errors, Supreme Court make errors, and therefore they are in every Supreme Court. The rule is that you are not bound by your previous decision. Why is it? Because there is an error. There is a review jurisdiction, which in East Africa we borrowed from India. Very rarely, sometimes, is that exercise. So I think it's a question of allowing magistrates, judges, judicial officers to make decisions freely, without interference, according to their level of knowledge of the law. That's why in East Africa we are investing a lot in our judicial colleges. Capacity building, I think, was mentioned here. And I think East Africa, I can say, because I've been in other countries, we are doing much better than West Africa in terms of investing in capacity building of our judiciary and the role played by our Judges Association, Magistrates Association in building capacity. So, yeah, I think this question is really fundamental about abuse of powers of arrest, because from the public eye, whether we like it or not, we are part of law enforcement. When we are not purely law enforcement, we provide oversight over law enforcement. But the public mixes up. So the powers of arrest, when we looked at it in the Criminal Justice Commission here, we said, first of all, the government from now on agreed that they will not be part of any case in which powers of arrest have been abused by public officials. Okay, so it means is an individual who will be responsible. And this arose in a case, there was a case in one of the districts where the district commissioner, your district governor, arrested. He had a power to arrest. He arrested somebody who was detained by the police by 5 days. And the court, I think rightly, ordered compensation. Okay, about 10 million to the district governor and 80-90 million to the government. So I think it's a good decision here that the government now and there's a directive from the Attorney General, that anybody who abuses powers of arrest, places somebody in custody, this person should be sued individually. And here the Tanganyika Law Society is playing a role. They've brought up a number of cases recently about people being arrested by the police on orders by politicians or public servants or ministers and so on in their own. I think for us, maybe an oversight role to be more vigilant. We cannot initiate proceedings, but from that, but just to be conscious of that and then to look in terms of really how we can engage maybe with the bar in bar bench relationship and so on, because I think the prosecution has a bigger role in that than the judiciary.
Thank you, my Lord Chief Justice. Yes, my Lord Justice Nzoiki.
Yes, my name is Nzioki Makao from Kenya. I commend the entire panel for the discussions that we've had, but my question goes to Honorable Muthoni. When you spoke of the rights of a mentally ill person in conflict with the law, I know you didn't get to dig in deep, but I just wanted to know, do you see a solution either in legislative reforms, or is it in terms of innovative approaches to handling that person who is mentally ill in conflict with the law?
And that will be our last question, unfortunately. We can confer with the facilitators during the break and during the conference. You may answer.
Thank you for the question, Judge. In this one, I would like to give it over to a more experienced colleague. Maybe I can nominate Honorable Gatheru Lewis.
Would the nominee please rise? Is the person here? Just put up your hand so we can give you a microphone. Okay, at the back.
He may not be here.
He's there.
He's there.
Good afternoon. I'm sorry, maybe I did not get the question right, but if the question is about whether the solutions lie in the legal reform or from the jurisprudential point, I think because we have already declared certain sections unconstitutional, then it means it will need some legal reform as well, so that the law has to be amended to conform with the jurisdiction, the jurisprudence that we have developed. I hope I'm right. Was that the question?
Thank you, Honorable, for that answer. Thank you very much. We shall continue this discussion. I would like to thank the Honorable, the Chief Justice Othman. I want to thank our honorable facilitators, speakers today, and you, our delegates, for staying here, participating, and just making the room warm during this session. The AC is quite brutal for some of us, but we thank you very much. Enjoy your lunch. Thank you very much.
Can we put our hands together for the presenters and the moderators? Yeah, we must apologize that time is not in our favor. We are trying to redeem the time that we lost in the morning. Before we go for lunch, I have some few housekeeping announcements to make. First of all, I would like to recognize the presence of Lawrence Mchome, the first vice president of Eamja when it started. Justice Mchome. Yeah, he's standing on that side. He's the first vice president when Eamja started for the first time. Thank you very much, my Lord, for coming. May I announce now where we are going to have lunch? Because of the number, we have 3 places where we are going to have buffet. And I'll mention the coupon numbers. I think you all have your coupons. Number 1 to 8, you are going to the grill. The grill actually is inside the main restaurant on the left. On the left-hand side, but you'll find somebody. There will be people. Actually, the ushers will be showing the posters so that you can follow them. So from 1 to 8, you'll be going to the grill, and then Mpingo. Those from 81 to 200, they'll be going to Mpingo, and then the rest will be going to Sabasaba. That is 201 up to 450. They'll be going to the main restaurant in Sabasaba. Can I repeat for the last time? 1 to 8, you'll be going to the grill. The grill actually is inside the main hotel on your left-hand side, but you'll find people outside. They'll be able to show you. And the Quicker and Mpingo, 81 to 200. It is just straight on this side, on the back of this hotel. And then the rest will be going inside the hotel on your right-hand side. That's where the main restaurant is. This will be 201 to 450. But all the same, you'll find ushers will be outside. Actually, they'll be able to show you where you can find your hotel. Otherwise, bon appetit. Okay. Thank you. Thank you. We are coming back after 1 hour from now. 1 hour from now, we are coming. We'll be back to that.